Thank you everyone for joining us this afternoon. My name is Zachary Raymond. I have the great privilege of delivering this webinar with you via Zoom with Lloyd Kopenbarger, our esteemed founder of Kopenbarger and Kopenbarger. I'm the Executive Vice President of Lifestyle Financial Services. If you have been on any of these webinars before, you may have seen my partner, Charles Sosa. I hope that I will be an accurate and adequate substitute. And I look forward to taking the next moments of your time, a couple minutes this afternoon, to walk you through a little bit of planning for retirement. So without further ado, we'll get started. And for anyone who joins on late, I won't be going terribly fast, so you'll be able to pick up right in the slides. So here's our basic agenda of how we're going to run through this afternoon's webinar. I'm going to dive right into the retirement basics. A few things to keep it in mind as we'll go through this webinar is the world is changing, and I always tell people that that directly impacts your retirement planning. Many years ago, when the 401k was introduced or when retirement planning was introduced, there was a concept of saving for a time when people were no longer making income through work or other investments. Also included in this was Social Security, which has a very, very short track of history, was started in the 1930s. Today, retirement takes on many different aspects, and there's a couple of the lists down below, but I always like to tell people, visualize what you would like to do when you have many hours in the day back to you, such as playing with grandchildren, going on a fishing trip, or traveling to see other parts of the world that you couldn't while you were working. All of that factors into the retirement plan, and it relates back to how we plan for it. As I mentioned earlier, time is one of the things that we don't get back. You have 24 hours in the day, and then you have the next day and the next day, and it builds up these chapters of your lives. Longevity in investing takes into account time. And we also must consider nowadays, as we'll talk about more, people are living longer and longer. When we mention investment periods and other considerations, we think about this not just in days, weeks, and months, but years and decades. And it's very important to keep that in mind when we're talking about retirement, because there are many, many years that people will look forward to in retirement, and we have to take that into account. Now more so than ever, we also have to take into the implications of health. You know, the father time is undefeated, I always like to think, and we must be mindful not only of our financial health, but also of our physical health. And so there are certain factors that we take into account in the retirement planning considerations, such as incapacity, limited mobility, and nursing care. The only thing that is free in this world is breathing the air that we get to enjoy every day. We have to budget. I usually discuss this with clients about talking about the 3-bucket approach. Things that are essential that you need your money to do, things that are very important that you would like to have your money do, and things that you want to have extra resource available at the end of the day or after all the essentials are met, so that you can enjoy other aspects of life. However that takes shape, for each individual, it is different. No plan is the same, and we dive into, at Lifestyle Financial Services, how to implement this plan for your specific best interest. Some of the resources that we look at are things that are going to be reward to you, such as Social Security, or maybe there is an inheritance component through a previous family member's estate planning, or some other investment that has been present and made for your well-being. We then take that as part of the plan and try to target certain benchmarks or goals that are of value to you. And this might be simply never having to worry about monthly budgeting again in retirement, or having a windfall that allows you to take multiple trips a year, or one really nice trip a year, pay for someone's wedding or a graduation present. Whatever the specific idea or target is. We help incorporate that into a plan and model for it. The biggest thing nowadays that we'll talk about in a few minutes is risks. The last couple of years have been very good in investing, and so we haven't really had to think about risk in terms of planning for retirement, but they've always been there. And even today, now so more than ever, I like to think, is it more important to revisit those risks and understand their proper place and put them in perspective as it relates to your plan. It is very important, and I always like to think that you should have three pillars of people who, when talking about money, you have a good communication with. The financial professionals who you work with, the estate planning professionals you work with, and the tax professionals that you work with. Estate planning revolves around all these finances and affairs, whether they be real assets or investment assets or other assets, and figuring out the most effective way to put them into a plan. Tax planning, we have to pay taxes. In the state of California, we have to pay a lot of taxes. So we definitely need to take that as an extra layer of planning. And it should never be a short conversation. It should be something that is very much a fundamental to your financial plan, and that then allows us to build on it. I think simple expressions are usually very helpful. So one thing to keep in mind, as Benjamin Franklin says, if you fail to plan, you are planning to fail. I think that these little one-liners are very useful, and they serve as a good reference point. I'll always tell people that when you come to a planning consideration in financial planning, you don't need to hear very big words. I and my partner at Lifestyle, Charles Sosa, have to be able to explain things effectively to you as if we're talking to a fifth grader, not because anyone is limited to a fifth grade understanding, but because these big words and phrases are not going to do any service to you, especially planning for retirement. You want to have an easy plan that you can always fall back on and have someone to then explain any areas of it that are needing to be unpacked a little bit. So here are a couple of fun words that are out and about nowadays that we'll be talking about for the next couple of minutes. Inflation and all of the different versions of inflation that you may have heard of in the news or read about, such as stagflation, reflation, deflation. Retirement account strategy. Retirement account strategy is not just having a retirement account, but looking at all of your investments for your life and retirement. That is a full retirement account strategy, and planning for it, whether or not you're in the early stages of retirement, well into retirement, or just starting. It all plays into the overall retirement strategy and plan that should be set and able to be built on for years. Global and local politics. We are not politicians. We're financial planners and advisors. We are paid for professionals. We are here to do the best job we can. And today, more so than ever, that involves and demands that we be aware of world events, what's happening in politics abroad and in the United States, because that directly impacts financial planning and retirement planning. So it's always used to just be aware of your surroundings. You don't just want to go out and play on a field in the middle of a thunderstorm. You always want to know what the weather's like. Growth versus value. These are investment terms. They have new meanings in this current investing cycle where we are today. And part of the financial plan is to take these words and give very simple definitions and figure out how they relate to your retirement planning. And stocks versus bonds. These are the bread and butter, the foundation stones, the framework of all investment planning. You build on layers as appropriate, but you always want to start with something simple, because simple is also very effective at times if it's given the right chance to work as part of a strategy. So I mentioned inflation. The definition of inflation is simply the change in the value of money and what it can do for you. We have experienced inflation not seen in over 40 years, and it's likely not to go away anytime soon. So part of an investment plan is to look at your current strategy, see what is working and see what is not working, and plan for the short term, which say the next 3 to 6 months, the midterm, which is 6 to 12 months to 18 months, to long term, 2 years plus. That's why we have these different goals that we try to plan for. If you're trying to plan for something short, such as maybe buying a new car or helping a kid who is currently in college pay the rent for an apartment or textbooks, all of it has to be taken into perspective. And there's a plan that you can set into place so that you don't have to stress about it over and over and over. It creates a feedback loop of excessive fear that we want to try to remove when planning for retirement. Because in this retirement stage, you want less stress in your life. You want someone who won't ever hide the truth that is going out into in today's society, but will give you the facts and also give you the path on how to move forward. We always talk about risks. That there is no such thing as certainty, but uncertainty in the investment markets. And the timeline, years, decades, months, helps us plan appropriately. So we always want to have the right sort of strategy when thinking about this. I mentioned inflation. Inflation is something that is here to stay for the short term, for an intermediate term, and what it will do will set a new framework for investing. I mentioned that in the past there were certain retirement plans created, such as the 401k, or even farther back in the 30s, Social Security. These were all set in place with the simple concept of having resources when no longer working. And some of the models that people grew up having a framework of understanding or that were invested to try to achieve these goals was the 60-40 model, 60% stocks, 40% bonds. And it did great things. Now take into account that in volatility and the current monetary environment, you have to look at these models that were set in place and did great things in the previous regime or the previous investment cycle for previous retirees, and now look at how to go into the next investment cycle into the future and plan for that. For example, bonds are supposed to be a safe investment, but in this current inflationary environment, they're not necessarily the safest investment. Stocks are not necessarily the most risky investment. It matters what kind of stocks you are investing in. I mentioned we have to be aware of the world and politics and geopolitics. A few things that we keep in mind in investing is the Ukrainian-Russian situation. That directly impacts investing here in California. Also, we look at farther China's relationship with the United States. We look at trade overseas. We look at supply chains. These are titles or things that you've heard about in the news. Part of the planning process is we explain to you why it matters for your retirement planning, both in the short term and in the long term. And during the pandemic, when COVID changed how the world functioned, it left not necessarily scars, but marks that planning for have to now accommodate in the real world, such as webinars or working a partial in-person week, non-in-person week, a part-time employment, how these things impact retirement planning. People are able to move to maybe a different location to still work, how family structure is made. All of that comes into impact as a lasting remark or mark of the pandemic. As I mentioned, supply chains. It's not just getting things from point A to point B, but having inventory and making sure that companies are able to weather the next time that there's ever a slowdown, because it happened once, therefore it may be able to happen again, and we have to plan for that. So a couple of things that we always like to remind families and individuals at Lifestyle Financial is most people either fail to plan or fail to actively work on the implementation of their plan. I've been mentioning planning for the better part of 15 minutes, and it's really important to take this home, that we don't just come up with a plan, set it, and let it go gather dust in the corner in a file closet. What we do is we revisit the plan. We actively want to make sure that things are on track, or if there have been changes that are necessary, we put it into the plan. People's lives change all the time. Retirement plans change daily almost. So the plan has to accommodate some of the volatility in life. And markets do not go according to plan. So we have to plan for as much as possible. Even in that uncertainty, there are still areas of outperforming. I always tell people, you get rewarded for time in the market, not necessarily timing the market. When you have the plan, that is how the markets can create for you. You have this strategy and then watch it grow. And we have this commitment. You can call, you can email us, you can set up a free consultation just to simply see if your plan that you currently have with the investment professional you have is on track. We are not in the business of taking from any other advisor, but it never hurts to have a free second set of eyes and second words to simply make sure things are on track. Or if people don't have a plan, it is very important to remember, it is never too late or too past to start planning. Everybody has to start at a certain point in time. Now is as good a time as any. In retirement planning, as I mentioned, there are several different investment vehicles that we look at. 401ks or a group retirement plan, IRAs or individual retirement accounts, both traditional, which is pre-tax, and then Roth, which many of you may have heard of, after tax. Life insurance and all of the complexities of insurance, including, but not limited to, long-term insurance. Having some of that health costs, which is going to be one of the largest costs for many people, already take into account your plan, so that if your planning for retirement includes estate planning, which Lloyd will be able to talk about, it doesn't drain from the next generation or what you're trying to plan for the future. That being said, my time is done. I'm going to turn it over to Lloyd Koppenbarger, who will then talk about estate planning and the protection of your retirement plan through the legal lens.
First document that everybody should have as part of their protection is something called an advanced healthcare directive. This is nothing more than a health power of attorney that gives to another person the authority to act on your behalf to make healthcare decisions. Everyone over the age of 18 should have one, and certainly those of us who are more mature in age absolutely should have one, because of the likelihood of a sudden health condition that has to be reacted to very quickly by the people who are involved in our lives and who care about us. It takes effect when our doctor can no longer communicate directly with us. And I would encourage you to get one started now. You can get it done by a qualified estate planning attorney. Some healthcare providers provide form advanced healthcare directives. Those documents are legal. They're usually not as comprehensive as most people would prefer to have. And so I would encourage you to get professional help in creating this document. Anytime you change your mind about the people that you would want making healthcare decisions for you, you need to redo your advanced healthcare directive. Anytime you change your mind about some of the fundamental decisions that have to be made under a healthcare power of attorney, you should change that document. For example, many times people originally want to make donation of organs or tissue, and then they have a health condition that makes that unwise for them to do that, either because they have cancer or some other communicable disease, and having a healthcare directive to donate organs or tissue can just create confusion. Another change is when you change your mind about how you would want decisions to be made, allowing your life to come to an end naturally when there appears to be no longer any hope of recovery. Sometimes people put procedural steps to be followed in making that determination. In any event, whatever your wishes are, you certainly should have an advanced healthcare directive. Another document that you should have is a financial power of attorney. A financial power of attorney allows you to give to another person the authority to take care of legal and financial matters for you if it's either inconvenient for you to do it yourself in the case of an immediate financial power of attorney, or give someone the standby power to do it in the case of a springing healthcare or financial power of attorney. In either case, the person can be given the authority to carry out tasks for you when it's either inconvenient for you to do it yourself, or when you're unable to do it because of incapacity or illness, or perhaps you're no longer available in the immediate area where action needs to be taken. One of the things that is really important, particularly as we become older, is to remember that if we don't have these documents in place, giving someone the authority to act for us, the only solution to deal with the care of someone who has not delegated this authority legally is to have the court appoint someone to act for them. That, for an adult, is called a conservatorship, and it requires going into court. The court determines whether or not a conservatorship is needed. The court determines who is to act as that conservator. The court gives that person the authority to do the things that are done under a financial power of attorney. However, those things have to be done with specific approval and authority given by the court. This is something that can be terribly time-consuming, particularly in our present legal system. Sometimes you're dealing with a situation where it can literally take months to get into the court on a simple hearing. Right now, I'm waiting to have a hearing established for a person who passed away in January. They didn't have a will or a trust, and the first hearing date we could get established was at the end of August. And so to the extent you have these documents in place where you don't have to have the court involved, you are almost certainly guaranteeing a significant time savings by having those documents. In the estate planning process, probably the most familiar to you document is a will. A will is just nothing more than a legal document that tells the court what you would want done in the event of your death. For example, it says who is to be in charge of your estate. It tells how your estate is to be distributed among the people that you wish to receive what you have when you no longer need it. It allows you, if you're a younger person, to name guardians of the person of minor children. Wills always have to go through the probate process. They are always under the supervision of the court. That means that even though wills are inexpensive at the beginning of the process, when you create them, they become quite expensive when they have to be carried out at the time of your death. And so there are other alternatives to will, and we're going to talk about them now. The will, as I've already indicated, has to go through probate to have any legal effect. And the probate process is basically set up to accomplish about three things. To make sure that any debts or obligations owed by the person who died are settled from the assets of that person, so that anyone who was doing business with or was owed an obligation by the person who died receives payment for that obligation. And that includes government, that includes individuals, whoever might have had transactions with the decedent that resulted in the decedent owing monies to that person or entity without them being paid prior to the decedent's death. It also allows the person who passed away for their representative to collect any debts or obligations that are owed to them. I deposited a check today at lunch that was payable to a person who passed away some time ago, and it was just now settled and the check issued to make that payment. And so in the process of settling this person's estate, we were able to get that check. And so the proper people will benefit from the monies that were owed to the person who died at the time of their death. But probably the most important aspect of probate, and the one that is most important to solve if you want to avoid probate, is transferring ownership from the name of a dead person to the living people who are entitled to receive the property and use it to their enjoyment and for their benefit during their lives. And this is the key thing that must be resolved to avoid the probate process. Every probate system in every state in the United States and every country in the world has some form of a probate process. And that probate process is pretty legally circumscribed. And the reason is you're dealing with the property of someone who no longer can tell anyone what they want. And so the possibility of fraud or the possibility of wrongdoing is very real. And so we have very strict controls over the documents that are allowed to direct where a person who passed away, financial and personal resources are to be distributed. This process is a public proceeding, so anybody who is curious can go to the public records and find out all about the business of the person who died and the people who are handling the estate and how the estate is to be distributed. In most cases, the probate process is relatively expensive. It runs between 5 and 7% of the gross estate in almost every state in the United States, and certainly in California, that is the case. Probably the most popular method to avoid the probate process is a document called a living trust. And the reason the living trust can avoid probate is because it transfers title to the property owned by the person while they're still living, and it doesn't have to be transferred after their death. Now, how does that do that and still protect the rights and the privileges and the benefits of the person who owned it and who created the trust? Well, first of all, the trust is nothing more than a contract. And that contract is between the person who creates the trust and a person called the trustee. The person who creates the trust is the settlor of the trust. They establish the terms and conditions that govern the operation of the trust. They name the trustee, and they can even name themselves as a trustee as long as they are mentally and physically able to act. So a person who wants to create a trust can create a trust, establish what is to be done with the trust, both while they're competent and living and after they're deceased. And they can be the trustee of it as long as they're able to act themselves. So they end up with the same control over their property that they had before they created the trust, but the trust creates a form of ownership of the property such that it doesn't have to go through the probate process when the settlor dies. The trustee carries out the wishes of the settlor. And the trustee is the person who is most important in designated as a successor. As long as the person who creates the trust is the trustee, you're pretty confident the trustee is going to be carrying out the wishes of the person who created the trust, unless they become mentally or physically incapacitated. But when that trusteeship shifts to someone other than the creator of the trust, then it is critical that we make certain that that person is someone who follows the rules of the trust, honors the contractual obligations of the trust. Even though it is a crime for them to violate the terms of the trust, it is much easier to have someone who's honest and carries out the duties than it is to go into the legal system to try to force someone to do what they should have done and what's proper. Remember, though, that a trust is limited to being able to protect only the assets it owns. So if you own something in your name and you have a living trust, but you don't transfer the ownership of that from your name as an individual to your name as trustee of the trust, and you die, that property will go through the probate process. The trust will not eliminate the need for probate in that circumstance. Now, what are the benefits of a living trust? Well, clearly the most immediate benefit is that it eliminates the need for the probate court. If you become disabled during a lifetime, it eliminates the need for a conservatorship. If you die, it eliminates the need for a probate. But even more important, in my opinion, than the protection from the court expenses, because there are some expenses in administering a trust, although they're not nearly as great as probate is. But the more important benefit to me is it allows you to deal with the circumstances of your life with privacy, because almost all of us have circumstances in our lives that we have to deal with that we would prefer not to be a matter of public record. For example, a child who has special needs that you want to set up special provisions for, someone who has some type of addiction who needs to be protected from themselves, perhaps someone who is not as wise as they should be in handling their personal life and personal affairs, specifically financial affairs. And so the trust allows us to deal with the realities of our life in plain language, dealing with realistic, real world solutions without it having to be made public and made aware to everyone who is curious enough to seek to find out what's in our document. The living trust also allows us to take steps to avoid federal estate taxes to the greatest degree possible. Right now, with proper provisions in a revocable living trust, a husband and wife could leave $24,120,000 free of federal estate tax at their death. Now, that's not going to remain at that level forever. It's going to be reduced in 2025. But regardless, that is a really significant sum now. And after 2025, it will be reduced to somewhere around, with a properly prepared trust, somewhere around 12 to 14 million, which is still a significant sum of money. It also allows you to deal with troublesome situations without getting a judge involved. It allows you to put the right person in charge of the care of someone who needs care, a minor child, a disabled adult child, without having to incur the expense and the publicity of a formal conservatorship or guardianship proceeding. And more importantly, the trust, more than any other device, allows you to make sure that your wishes are carried out when the time comes that you're no longer there to express your wishes or see to it that they're carried out. Trust also has a protection document that goes along with it. And that document is, in my opinion, misnamed. It's called a pour over will. It really should be called a safety net, because what it does is it covers things that the trust is unable to cover. For example, it allows you to, with the will, take property that's been inadvertently or deliberately left out of the trust and put it back in the trust as long as it does not exceed a certain monetary limit. That monetary limit in California is about $160,000. The will also names an executor, so that if there are actions that have to be taken in the probate court, there is someone named and given the authority to do so. It allows people with minor children to name guardians of the estate of minor children and guardians of the person through the court system if that is required. And it also allows the trustee of the trust and the executor of the will to be the same person, so that that further simplifies transactions between the two documents. The taxation of our personal estates is an extremely important thing, because just because we pass away doesn't mean we no longer have to file an income tax return for the last year of our death. It doesn't mean that if our estate is greater than a certain monetary level, we don't have to file estate tax returns. There are certain benefits that can be obtained for our surviving spouse with a properly prepared estate plan, notably something called estate tax portability election. I'll talk about that a little more later. We also get a step up in capital gains tax basis for property that has capital gain trapped in it at our death. In other words, if we bought something for $10,000 when we bought it, and it's worth $1 million when we die, the cost basis goes from $10,000 to $1 million as a result of our death, and that eliminates taxation in the hands of our beneficiaries to the extent it increased in value during our lifetime. We also, in some cases, can produce favorable results for property tax. That is more difficult in California since the passage of Proposition 19, but there still are some things that can be done to transfer property to children and avoid a new tax basis for property tax purposes. The federal estate tax takes effect when there's a transfer at death from your estate to your beneficiary. As I've already mentioned, each of us at present has the ability to pass up to $12,060,000 free of tax. And so there is no tax return that has to be filed, and no tax has to be paid as long as the transfers made by us to other people is less than $12,060,000. We also get to transfer any amount to charity, and that's not included in the $12,060,000. And so that issue of federal estate taxation is one that is quite complicated and probably should not be undertaken by someone who is not quite knowledgeable in the federal estate tax law. We talked about the exemption, the portability amount, and that's a pretty significant thing for people to know. Let's say that Laura and I, Laura is my wife, let's say that we have an estate, and my portion of that estate is $3 million. Her portion of the estate is $3 million. I pass away and the 3 million that I have does not go to Laura outright. It is put up so she gets income from it as long as she lives. And then when she dies, whatever remains goes to our children. By filing a federal estate tax return and electing to protect portability, Laura can keep the other $9,060,000 of what I could have passed tax-free at my death. And that allows her, over the course of her lifetime, if she lived long enough, that her 3 million became more than $12,060,000, she could use some of my exemption to cover the tax liability that she would otherwise have. And so I would encourage everyone with an estate that is large enough that the spouse might be faced with a estate tax at their death, but there is not an estate tax at the death of the first spouse to die, to consider electing portability and protecting that additional protection for their surviving spouse. In the living trust, there are several special provisions that can be made and taken advantage of. One of the ones that I am most likely to recommend to married couples, particularly married couples who've been together for enough years that they've acquired financial resources as part of their marital lives, is an AB trust or a bypass trust. This is at conflict and many times with other advisors and other attorneys and other financial advisors, because they only look at the tax consequences. And I recommend an AB trust or a bypass trust, even if there isn't federal estate taxes, because the bypass trust does a couple of things that can be really significant. First of all, that portion of the estate of the one that dies first that goes in a bypass trust to be held for the benefit of the surviving spouse as long as he or she lives is protected from creditors. If the surviving spouse is in an auto accident or gets sued by somebody, they cannot touch that portion of the estate that belonged to the spouse who died first. And so that guarantees that money is going to be there for the surviving spouse as long as he or she lives. It also provides what I call anti-floozy or anti-gigolo protection. It means that that portion of the estate of the one that died first cannot end up in the hands of a second wife or a second husband to go to strangers to the family and leave the children of the marriage disinherited. And so those are things that every married couple should think through. This is not an attorney decision to make. It's a husband and wife decision to make. But it's a very important decision because it can result in some very undesirable circumstances occurring if husbands and wives don't think about it carefully and make sure that their wishes are fully set forth so that they can be properly carried out even after the death of the first one to die. I've already mentioned that it protects from creditors, it protects from lawsuits, it protects from bankruptcy, it protects from the IRS, and those are important things. But there are other things you can do as well. This, what I was talking about, was for the surviving spouse, but you can set up a provision in your living trust for your children that give your children all the same protections that the bypass trust gives your surviving spouse. And so the inheritance of a child can be set up in such a way that it cannot be reached by creditors. It can't be reached by lawsuits. If they're in an auto accident and somebody gets a big judgment against them, they can take everything else that child has, but they can't touch the inheritance you've left to that child. Bankruptcy courts can't touch that inheritance. The IRS can't touch that inheritance. And sometimes, even more importantly, a divorcing spouse of your child cannot get any of that inheritance in the event of a divorce. And so every family that has children where there's going to be a significant inheritance left should seriously consider these kind of protections for their children. It is not a simple revocable living trust that has these kind of provisions. It's more expensive, but the protection it provides is a quantum leap beyond the normal protections in a normal revocable living trust, even one with bypass trust provisions. And so if you're in a situation where your children are going to be receiving an inheritance from you, where each one of them would receive more than $250,000 to $300,000, it's really something you should discuss with a knowledgeable attorney. One of the things that has changed that affects almost everyone today is the provisions for the transfer of their deferred compensation accounts, their 401ks, their IRAs, their SEP IRAs, their Roth IRAs, those kind of assets. And the big change has been that for the person whose IRA it is, they no longer have to take it at 70 and a half, they can take it at 72. But the big change, and the one that you have to be concerned about, is for any beneficiary other than your spouse and certain disabled or other special beneficiaries. Normal adult children would have to receive that IRA and be taxed on it within 10 years of the date they received it. And no longer can a child take the IRA out over their life expectancy. And so this is something that you ought to sit down with your financial advisor and discuss very thoroughly with your financial advisor. And after you've discussed it with your financial advisor, he may encourage you to see an attorney to help you make sure that the beneficiary designation forms on that IRA are set up to provide the maximum protection to your ultimate beneficiaries of that very important financial resource. Never forget the possibility of utilizing lifetime giving to enhance the lives of your beneficiaries and also to defeat the tax man. First of all, remember that you can give $16,000 every year to as many different people as you want, excuse me, and you don't have to report it for tax purposes. They don't have to report it for tax purposes. As far as the government's concerned, it's a tax neutral transaction that nobody has to report. You also have the ability to give away during your lifetime exemption, that $12,060,000 amount that you have a right to leave tax-free at your death. However, remember, when you make a gift during lifetime, the person who receives that gift also receives your cost basis. And if you kept it until your death and gave it to them at your death, they would end up with a new cost basis equal to the value of the property at your death. Let me use the example I used earlier. You have a $10,000 that you paid for stock that you bought back in the 1960s is worth $1 million today. If you give that stock to a child now, there will be no gift tax because it'll be covered by your exemption amount. But when your child sells that stock, they will be faced with a $990,000 capital gain on that stock. Whereas if you had kept it until your death, they would have had $1 million tax basis, and they would have had no tax if the value was $1 million. Remember, for your investments, there's a new cost basis when someone dies. That applies to anything that has capital gain. The same is true with real property. In California, you have to remember that the property taxes are going to go up on almost any property that is in your estate when you die that goes to anybody other than your spouse. And the only exception to that is your home, and only then if a child receives it from you and they live in it as their personal residence. And that doesn't apply to very many people. Cash, of course, is not taxed for gain purposes because it always gets less. Every year that you have cash, that cash becomes a little less valuable, but it will be taxed at its face value for federal estate taxes in your estate. I'm not going to get into the Prop 19 change other than to say that if you have a home that you want to go to a child, you need to sit down with your attorney immediately and take steps to put special provisions in your estate planning documents to make sure that child gets that property at your death, and make sure that it's done in a way that's fair to the other children and in accordance with your wishes. When you have property, you have a potential lawsuit in the making, because if people get injured on that property, if something causes harm to someone on that property, you almost certainly will be made a party to that suit. And if the judgment goes against the property, it'll go against you personally, and it can not only take the property that the person was injured on, but all of the other financial resources you have. One of the ways to avoid that is to create a legal entity called a limited liability company. And this is a legal entity that the government has established in California, and it's true in almost every other state in the United States, where you can put real property or any other property that has risk associated with it in that LLC. And if someone is injured by that property or on that property, the maximum liability that you have is the loss of that property. They can't go against your other financial resources to satisfy the extent of their injuries. One of the things that I encourage everyone to do, and this is part of your legacy, is to think about the institutions in your life that have benefited you and your family, and consider whether or not you should provide support to those entities. I had the privilege a few years ago to help a man make a major gift to a university to provide scholarships to young people with a certain type of handicap. He had had that handicap as a young man, and one of the professors had come up with a treatment for him that allowed him to cure that handicap and allowed him to become quite successful later in life. And he gave a significant gift to this university in honor of the professor, excuse me, who had given him the gift of treatment that allowed him to live a normal life after the receipt of that treatment. And every one of us have been benefited by colleges or churches or other worthy organizations that have fulfilled a purpose in our community and in our lives that was worthwhile. I'm almost out of time, but I want to mention one other thing that can sometimes be very important. One of the major risks that we have as we get older is becoming incapacitated, needing long-term skilled nursing care. That long-term skilled nursing care in Southern California and in Northern California is going to run somewhere between $12,000 and $20,000 a month. Most people cannot afford that, and it will be devastating to them and their families financially. There are ways to plan in such a way that you can qualify to receive Medi-Cal assistance from the state of California if you need long-term skilled nursing care. I'm not going to talk about it here, but our firm has been providing that type of protection for the last 12 years. It has proven successful for our clients. You can never, as an attorney, predict what the law will be tomorrow, but based on the principles that we're following, I would anticipate that we will be able to continue to help our clients protect their financial resources and still qualify to receive the governmental benefits that they've been paying for with their taxes all these years that they've worked. I've already talked about leaving a lasting legacy. Let me encourage you to share your value system with your children. Tell them what has made your life a successful one. I like to see families create a family constitution. That family constitution just basically talks about the values that you and your parents and your grandparents have shared that has made your life successful, and that you hope your children will govern their lives so that their lives can be successful. Good lives don't just happen by accident. They happen because successful principles are incorporated by the people who live those lives, and those principles allow their lives to be successful, even in the face of some very difficult circumstances that life sometimes throws at us. And so share those kind of things, share family recipes, share memories. If you have items that have ancestral value or personal emotional value, share the history of those things with the people who are going to be the recipients of it. You can take a thing and make a treasure out of it by sharing some of its history and why it was important to you. I've already talked about many of the documents that help you protect a legacy, but you actually have to help the attorney with making the written legacy, what I was just talking about a few minutes ago. And the role of a good financial advisor, the role of a good attorney, is to help you do what you would do yourself if you knew what we know. There's nothing magic about being an attorney. There's nothing magic about being a financial advisor, except that we have devoted years of our time and years of education to develop knowledge in areas that you don't have the time to develop because of the busy lives you lead, earning the financial resources that need to be protected. And so remember, we're just an extension of you. We help you accomplish what you want to accomplish, both from the standpoint of using your financial resources to the maximum advantage for you and your family, and making certain that those financial resources are utilized to the maximum degree possible, utilizing the law to make sure your wishes are carried out. Again, I've already talked about family history, records, mementos, pictures, videos. It's probably a good idea to make copies of these family items and make sure everybody in the family has a copy of all the pictures that anybody would have an interest in. We are committed to helping people preserve their legacy. And if you're a person who sees the value in that, don't hesitate to make an appointment with Kobenbarger and Kobenbarger and come in and talk to us about how you can create documents that will protect your financial resources and also reflect the value of your life by setting forth the values that you have in a proper way to your children and grandchildren and even generations unborn. We encourage you, I suspect many of you who are listening to this webinar are already clients of Kobenbarger and Kobenbarger. If you are, remember that we rely on you to help us help other people. And if you have family or friends or other people who need the kind of services we provide, need the kind of services that Lifestyle Financial provides, don't hesitate to recommend us to them and encourage them to at least come in and have a consultation to find out what they need to do to properly protect themselves. And we tried to act in every transaction that we're involved in from a position of utmost integrity and concern for the clients and for the people they love and care about. Remember that you need to be aware of all these tax issues and investment issues if you're going to properly protect the financial resources that you've spent a lifetime acquiring through your personal efforts and hard work. And there is nothing inappropriate about asking someone who has more expertise in a particular area to take a look at what you have and help you maximize the benefit of the resources that you have. Remember, we're here to help you. We look forward to hearing from you. You can get in touch with us by calling the 1-800 number, 1-800-244-8814. That is an international 800 number. Anywhere in the country can call us at that number. Anywhere in California. You also can reach us at our website. And I'm going to ask Zach to come back on now and share the telephone number for Lifestyle Financial.
Lloyd, thank you. If you need to reach us, you can reach us at 949-833-7673, and we are here to help you. As Lloyd always says, you know, when you come into Lifestyle or Kopenbarger, you're family, and we try to treat you as such.
When you come into your appointment, be sure and bring your existing estate planning documents if you're meeting with either the attorney or the financial planner. And to the extent you can provide us information, it allows the appointment to be conducted much more quickly and much more efficiently and much more productively from your standpoint. If we don't know anything about you, we can't help you. And so complete the data questionnaire. If there are sensitive subjects that you're concerned about, keep those, but fill them out and have them with you, and then you can provide them to us when you meet with us if you feel the comfort level to do so. And also have a list of questions that you would like to have the attorney and the financial advisor answer for you, so that those issues that are of concern to you can be addressed quickly and conveniently at the meeting. Thank you so much for your attention. Zach and I appreciate you giving us the opportunity to spend this time with you. We went over just a little bit. We hope you'll forgive us for that, but we were a little bit late getting started. And so we apologize for that, but we were having a little bit of technical difficulty. Thank you, and God bless you, and have a wonderful rest of the week.